Cleveland, 2025. The wrong lawyer cost the family the house. The estate plan was filed. The trust was funded. 8 years of protection gone. Then Medicaid demanded $300,000 in 90 days. The autopsy shows the lawyer who drafted Mom's trust. He had never filed a single Medicaid application. In 23 years of practice, wrong lawyer pattern repeats in most cases we've reviewed. The counsel's note: research, not legal advice. Laws vary by state. Sarah's mother, Helen, lived in Ohio. In 2020, Helen visited her family estate attorney, the lawyer who'd handled her husband's will. The attorney drafted a revocable living trust. He told the family it would protect the house from probate. The lawyer was correct on probate. He never mentioned Medicaid. 4 years later, Helen needed nursing care. The cost was $11,000 a month. Sarah applied for Medicaid. The application asked one question that ended the plan. List every countable asset, including assets held in revocable trust. Helen's house was in a revocable trust. Revocable trusts are countable. Medicaid valued the home at $310,000 and denied the application. Sarah called the original attorney. He said, "I'm an estate lawyer. Medicaid is a different specialty." The family had paid him $11,000 to draft a trust. It did exactly what it was designed to do, and nothing the family actually needed. Estate planning and elder law are taught and licensed differently. Estate attorneys handle wills, probate, basic trusts, and tax minimization. Elder law attorneys handle Medicaid eligibility, asset protection trusts, long-term care planning, and guardianship. Most state bars do not require either specialty for the other. A lawyer can practice estate law for 30 years and never file a single Medicaid application. The credentials look identical on a website. Most families we examine believe the same 3 myths about hiring legal help. Myth 1. Any estate attorney can handle Medicaid. They cannot. Medicaid requires specific drafting and timing. Myth 2. The family lawyer who knows us is the right choice. Familiarity is not specialization. Myth 3. If the lawyer is expensive, the lawyer is qualified. Hourly rate tracks tenure, not Medicaid expertise. 5 questions separate a Medicaid attorney from a generalist. Question 1. How many Medicaid applications have you filed in the last 12 months? Below 10 is a flag. Below 3 is a stop. Question 2. What is your state's penalty divisor right now? And when did it last change? A Medicaid attorney knows the divisor by heart. Question 3. Do you draft Medicaid asset protection trusts in-house, or do you refer them out? Referrals out mean the lawyer is not the practitioner. Question 4. What's your fee if the application is denied on first review? Strong Medicaid attorneys offer appeal-included pricing. Question 5. Are you CELA-certified through the National Elder Law Foundation? CELA certification is the only nationally recognized elder law credential.
In the files we've opened, 4 patterns predict whether the legal team can deliver. Pattern 1. The lawyer who answers the 5 questions in concrete numbers. Penalty divisors, application timelines, denial rates, all named without hesitation. Pattern 2. The lawyer who has a paralegal dedicated to Medicaid filings. Volume produces specialization. Pattern 3. The lawyer who carries malpractice coverage that explicitly names Medicaid planning. Insurance writers track risk. Risk tracks frequency. Pattern 4. The lawyer who refuses to start without 60-month financial records on the table. Records first means the lawyer respects the look-back rule. State law shapes who is qualified to plan. California requires no specific Medicaid certification, but Medi-Cal eliminated its asset test in 2024. The rules shifted faster than most generalists tracked. Florida has the highest concentration of CELA-certified attorneys per capita. Estate recovery is aggressive. Specialists cluster where the risk is. Texas penalty divisors changed twice in 2023. Generalist pricing did not. New York runs separate community and institutional Medicaid rules. Only specialists handle both reliably. Compare Helen's file to a file from Phoenix, 2023. David and Linda hired an attorney who answered the 5 questions in 12 minutes. 47 Medicaid applications filed in the prior year. Penalty divisor named to the dollar. CELA-certified since 2009. The attorney drafted a Medicaid asset protection trust, not a revocable trust. 5 years later, David needed care. The application was approved on first review. Same disease as Helen, same federal rule, different lawyer. Helen's family lost $310,000. David and Linda's family lost nothing. The 5-question vetting sheet is in the description. haircouncil.com/checklist. Before we close this file, one more pattern from the cases. 3 actions repeat in the cases that ended with approved applications. First, families interviewed 3 Medicaid attorneys before hiring 1. Specialization is comparative. Second, families asked for the 5-question answers in writing, not over the phone. Written answers create accountability. Third, families paid for a 1-hour consultation with a CELA before signing any retainer. $500 to vet beats 5 figures to repair. One more pattern from the autopsies. The families who hired their existing estate attorney out of loyalty had no path to course correct. By the time the Medicaid denial letter arrived, the planning window was closed. The credential the rule respects is not the relationship. It is the filing history. Next on the Council's review desk, the silent transfer that started a different kind of countdown. The file closes here. Yours doesn't have to open the same way. New case every week.